In Vincennes, after the Polly Strong case, Amory Kinney and his associates remained active in their efforts to free other slaves and indentured servants.
I met a woman who said that she had heard of this lawsuit too, because, you know, she does genealogical research and she's a historian. And she gave me some advice for where to find the actual lawsuit. And once I connected with the state archives and found that actual lawsuit, it was a piece of tangible proof that this actually happened. It's proof! It's proof! That's how I felt. This is an actual piece of history.
Mary's lawsuit came about with the help of a familiar source.
Mary, please have a seat.
How did Amory Kinney and Mary get together? It's very likely that Polly and Mary knew each other, and they talked about Polly's case. It certainly would have been greatly discussed in Vincennes. This could have motivated Mary to secretly contact Kinney, or Kinney may have contacted her.
That he had had success in 1820 establishing that slavery was illegal, unconstitutional, and a logical successor to that would be the question, well, what about indentured servants? Are they also unconstitutional?
So, who made the first contact?
We don't know. We just don't know. You can infer the fact that when Kinney comes to town in 1817, very soon after that, he has a number of black clients that he has enlisted in habeas corpus proceedings, and one of these was Mary Clark's. But Mary Clark gets the credit for having accepted this lawsuit and agreed to go ahead with it against all this pressure that was no doubt put upon her.
Long came this lawyer. Amory Kinney was that boy's name. Amory Kinney, son of a preacher man, he was. That Amory Kinney and me put our heads together, sued that General Washington Johnston for my freedom.
Mary and Kinney filed a writ of habeas corpus in Knox County, claiming that General Washington Johnston held her without any just or legal claim. General was Johnston's first name, not a title.
I'm really concerned about this. I'm concerned about what it's doing for you. I'm afraid people are taking advantage of you. And have you stopped to consider what this is going to do to your people, too?
And she probably got some amount of pressure. Just as in today, when people take actions that will make folks uncomfortable, they get pressure from within as much as they get pressure from the outside, you know? So the internal pressure would have been great. People would have said to her, why are you starting trouble for us? Why are you doing this?
Well, this is just base ingratitude. I don't like this at all. I truly don't.
You can only imagine how much pressure was being put on her, not only by her owner or the person that owned her agreement, her contract, but the people of the community, a strong amount of pressure for her to give this up. And she continued on and fought on to the end. She no longer wanted people telling her to do this and do that, no matter how mild her owner was to her. And she was an adult person that was being treated as a child by this patron, this patriarch that was over her.
After what must have seemed like a very long time to her and her family, Mary's case came to trial in Knox County Circuit Court. Her argument, through Kinney, was that the state constitution declared involuntary servitude illegal. Therefore, she should be set free.
So Johnston is saying that she's an indentured servant, that she voluntarily indentured herself, and the local judge bought that argument. He said that this was an indenture, that she voluntarily entered it and signed it.
We have to get beyond just Mary Clark and what was going on with her personally. We have to get into this thing of what was going on all around them. What was the tone of the politics?
Not surprisingly, the Knox County Court said that Mary should be returned to General Washington Johnston to serve out the remainder of her indenture, and ordered that Johnston recover his court costs and charges from Mary. Mary and Kinney immediately appealed the decision to the Indiana Supreme Court. The court heard the arguments on November 6, 1821. Amory Kinney was not the attorney for Mary at the Supreme Court. His associate Charles Dewey took his place. The Supreme Court responded forcefully to Johnston's argument.
He says this was authorized and signed before the Indiana Constitution actually comes into effect. I'm entitled by virtue of the old law to have this contract enforced. Indiana rejected this argument right at the very beginning, very flatly. Indiana law, the Northwest Ordinance, the new Constitution says no slavery, no indentured servitude. What part of that don't you get?
Judge Jesse Holman read the decision.
Such a performance, if enforced by law, would produce a state of servitude as degrading and demoralizing in its consequences as a state of absolute slavery. And if enforced under a government like ours, which acknowledges a personal equality, it would be productive of a state of feelings more discordant and irritating than slavery itself.
And they say in the case of Mary Clark, how could it be that you would enforce a contract for service by giving the owner, so to speak, physical possession of Mary Clark? Utterly degrading it is, the very notion that you would have sort of permanent physical possession of somebody who had promised to labor for you. So they lay down a marker.
The Supreme Court said that, well, she might have signed it, but she obviously isn't voluntarily, serving this indenture if she brought a case to be out from under it. So it's the interpretation of the document.
When it got to the Supreme Court, then they recognized that that indenture, that was just another word for slavery. First time went to court, lost my case. Second time, took it to the Indiana State Supreme Court. Won at that time. Won my case.
After the judgment, when Mary was released from the contract, there was a court costs award to Mary Clark and to Amory Kinney. And it was for $24.44.5. And this document shows that the year after that decision, on March the 26th, 1822, General Johnston did pay Amory Kinney the sum of $10 for his legal fees, the rest of which was to be paid to Mary Clark.
Won $24.44.5. Didn't receive $1 or the half cent.
Amory Kinney may have received $10 for his work for Mary, but he was also on the receiving end of another kind of payment.
In the Knox County court records, there are cases of assault and battery where irate slave owners beat him up because they're losing their property.
Mean place Vincent was then. Mean place. Mobs chased that boy down, chased him down just because he had my case and a few others, chased him down and tried to beat him to death one night. Yes, they did. Wasn't some good folk. There was good white folk, just like there was evil ones, there was good ones. And pulled that mob off of that boy, they'd have killed and shown up.
And so after several years of this, he moves up to Terre Haute, and he is an attorney there for the rest of his life in Vigo County.
He also served 3 terms in the Indiana General Assembly, where he became a strong supporter of a free public school system, and he later became a judge. General Washington Johnston was a paradox.
Actually, in the year 1808, General Washington Johnston himself, who was Speaker of the House of the Territorial Legislature, was on a committee to look into legalizing slavery. And he produced a report which concluded that slavery was ethically and morally and economically wrong. He didn't talk about indentured servitude, mind you, but he did come out against slavery.
I really do think that while General Washington Johnston was a good man, everything that I've read says so, he was still a slaveholder.
Johnston died in 1833 in Vincennes. His grave is on a hill in Greenlawn Cemetery and is marked by a magnificent stone monument. Vincennes remained the home of Mary, Sam, and their 12 children. Mary died in 1840, 7 years after General Washington Johnston. She was 39 years old and had about 20 years of freedom to enjoy with Sam and her children. Amazingly, for that time, Sam lived until he was 96.
It was a precedent-setting case. It cleared the way for other people who were in her like condition to be able to be freed of indentured servitude contracts without taking it to the Supreme Court level, the way she had to take it.
2 African American women in Vincennes felt that they had an entitlement to take their case to court, and they followed through, and the Indiana Supreme Court, said that they were right.
They're prepared to say something that they know is not going to be universally accepted, something which would have been resisted by some people who had the capacity to resist, but they do it anyway.
Polly and Mary Clark. Obviously, these were women ahead of their day, and they were willing to step forward, just like the families in Brown versus Board of Education were willing to be the families to step forward, and that alone must have been a great act of courage.
This story is something that can be shared with others who can do the same thing. Because while Mary Clark was definitely brave, and this was definitely a precedent-setting case, there are a whole bunch of other Mary Clarks and Sam Clarks out there who survived that experience and who now have descendants here today to prove it.